Court calls the case, People versus Quadir Man.
And then now we have the people, Your Honor.
Assistant Public Defender Ben Benowitz on behalf of Mr. Mann, who is standing to my right. Sir, would you say your name for the record, please?
Quadir Man.
Thank you.
Your Honor, we would like to set this matter for exam.
All right. Discovery is complete.
Discovery is complete.
People had their witnesses available the 13th.
Who's that?
Preliminary examination in person, January 13th, 2026, 9 a.m. before 15th District Court Judge. Yes.
Your Honor, it came to my attention in looking at the defendant's jail calls before he was released and after he was arraigned. He made 50 calls to the victim from his PIN to her listed number after being arraigned. And that doesn't count the day that he was arraigned after he was arraigned. That only encompasses days exclusively after he was arraigned. He calls her 50 times. So I have concerns, given that also to Raymond, the magistrate indicated his concerns that he will not follow court orders and that he would go back to contacting the victim as soon as he was released. And it seems that he didn't even do that prior to being released. He did it while he was still in custody. So I have concerns, given now that he is out, for safety. I also have concerns given the facts of this case in which his grandmother is the person who reported the crime after she awoke to blood curdling screams from the victim and felt she had to call 911 after hearing the victim being slapped. So I have concerns for safety given that he was contacting her excessively from jail.
When was he released?
I'm sorry, could you?
When was he released from jail?
I believe it was the 26th and he was arraigned on the 24th after being arrested on the 23rd. Could I attempt to respond, Your Honor?
Go ahead.
My response is primarily based on the facts of the case. This complaining witness stated she was not assaulted. The grandma did not witness any sort of assault. As the prosecutor told you, she said she heard something. So there's no witness that actually witnessed an assault. So then, Your Honor, the police say he's laying on a mattress with a blanket on him, which we would commonly call sleeping. The complaining witness tells the police he has a head injury from falling down, okay? So he's sleeping and has a head injury. The facts of the felony charge in Washtenaw County in 2025 is that he had to be told 3 times to turn around and 4 times to back up. And that's a felony. And now we want to revoke his bond, which is basically a due process violation because you take away his trial right. His trial will be in about 8 months.
Why am I taking away his trial right?
Because if he's incarcerated, then it's make a get out of jail plea. I mean, he's talked to.
It's not, counsel. And quite frankly, this court resents that you even make that argument that this court would be involved in violation of anybody's due process rights. He's given conditions. If he does not follow those conditions, he pays the consequence.
I agree. I just indicate to the court, I don't think the person that the condition is regarding wants that condition. She didn't want any of this. And then
there's a way in which that's taken care of, not by him continuously calling. He knows he's not supposed to be
I mean, Your Honor, he's 19 and it's Christmas. I just asked the court to give him a chance until we have a date on the 13th. I mean, if this witness says he's contacting her currently, you know, she comes to court on the 13th and tells the court there's a bond violation. I clearly don't have an argument to that, but if the court would let him stay out to the 13th and he's not going to contact.
I don't know what he's doing now. I mean, that's what part of the problem is. Part of the problem is that, and by the way, not only is your client entitled to due process, but the people are entitled to due process. Everyone is entitled to due process, and it is my job to make sure that it happens. If I believe for whatever reason that he may be interfering with the people's due process rights to fairly present their witnesses and have their witnesses present, then I'll take action, which I'm about to do now. Right now, his bond is revoked. Defendant is remanded. Thank you.
Just revoked once.
Yes, and his phone privileges while in jail are revoked. Put that, can you?
Would the court only revoke as to the two persons with no contact orders?
I'm revoking his phone privileges.
Okay, thank you.